Massimo. I'm grateful for having the opportunity to participate in this great event. Thanks, the organizers and the university. The title of my paper is Some Doubts About Robert Alexys' View on the connection between law and morality. Whenever I read Robert Alexys' writings, I am so fascinated by their concise style, lucid structure, and forceful argument that I am greatly inclined to believe him almost everything that he maintains. In fact, my inclination has even grown in the course of time when I saw how his contributions to the main fields of his thinking, as Massimo told you already, legal reasoning, constitutional rights, and the concept of law, have not only developed step by step to highly sophisticated conceptions of these fields, but also grown together to a comprehensive and cohesive theory of law that, in my view, is unparalleled in contemporary legal thinking apart from Ronald Dworkin's work. I should not conceal, however, that my sympathy for Alexys' work has also been nourished by the fact that its outcomes widely fit with my own convictions, particularly the commitment to the tradition of enlightened thinking, as well as to a constitutional political order that incorporates human rights, social justice, deliberative democracy, and rational discourse. Nevertheless, after some moments of critical reflection on Alexys' considerations, I am often afflicted by doubts about some of his points, since I cannot help thinking that his picture of law is somewhat too good to be true. I would like to take the opportunity of the present workshop to raise some doubts about Alexys' view of the connection between law and morality. Since this view has already been extensively discussed by other scholars who expressed similar doubts, I am in the unfortunate situation that I am going to deal with questions which may appear to have been settled before. Yet I hope that my considerations will not be completely superfluous, for it seems to me that my doubts somehow differ from the bulk of critical comments on Alexys' theory in the literature that I know, because my target is merely a more or less slight modification of some of his theses rather than their refutation. Anyway, the theses I want to scrutinize address the following issues. First of all, the dual nature of law, furthermore, law's claim to correctness, and finally, the idea of an objective morality. In the written version of my paper, I have also a brief recapitulation of Alexys' view, but for reasons of time, I want to skip this part and jump to the second part of my paper, which contains my doubts. My problem with Alexys' thesis regarding the dual nature of law addresses more its formal feature than its substance as such. For the way in which he introduces the thesis from the outset already presupposes by definition its very demanding corollaries with which its plausibility actually stands or falls. My doubts about this form of the dual nature thesis refer mainly to the ideal dimension. Alexys' understanding of this dimension relies on two presuppositions, namely law's claim to correctness and the existence of an objective morality. It is true that Alexy, after his initial presentation of the dual nature thesis, which conceptually implies this presupposition, proceeds with particular arguments in their support, but he doesn't indicate any awareness that his dual nature thesis itself were doomed to collapse if one or both presuppositions would turn out to be questionable. Consequently, in order to scrutinize the dual nature thesis, I want to take a closer look at its corollaries in the following. As to Alexys' thesis of law's claim to correctness, I have, as some other scholars before, serious doubts about his assumption that the law itself is capable of raising this claim, even if understood in the figurative sense that the claim is actually raised by legal authorities or officials as law's representatives in its behalf. First of all, I am not sure whether there is any legal authority or official who could reasonably make a claim to the correctness of the respective legal order as a whole. Admittedly, its constitutional assembly may, or even ought to, claim the correctness of the constitution. Its legislative bodies may claim the correctness of the laws issued by them. Its judges may claim the correctness of their judicial decisions, and so forth. But I doubt that all these particular claims amount to an entire legal order's claim to correctness, understood as a claim that the order as a whole is in fact correct. At least I do not know of any logical principle that would make such an aggregation of claims possible. Besides, it were very imprudent of legal authorities if they claimed correctness for legal decisions beyond their own responsibility, since they can never be sure that other authorities are committed to meet this claim. Not even a constitutional assembly that has issued a perfectly appropriate constitution can take it for granted that all or most officials endowed with legal powers will accord to its principles. Alexy counters these and similar objections with the argument that the claim to correctness may be ascribed to law itself because its authorities and officials who actually raise the claim do that as its representatives who are empowered to act in behalf of the law. This argument, however, presupposes that a legal order may be conceived of as a sort of an organized collective body that, as a whole, is represented by its officials whose activities are to be attributed to the respective collective. At the first glance, this argument seems insofar plausible as modern legal orders are closely connected to a state that indeed has the form of a hierarchical organization whose supreme powers have, or at least ought to have, control over inferior officials' activities, which therefore may be ascribed to the state or its legal order itself. Yet, apart from the fact that this argument only applies to fully developed legal orders, it does hardly take account of the complex structure of law as a social practice. For this practice is not simply an organization, but rather an ongoing social process that is only partially directed by an organized institutional body, but partially also consists in a constant, more or less spontaneous flow of innumerable individual activities which never form an unified whole that may raise any claim at all. I suspect these problems with Alexys' correctness thesis result from his mixing two sorts of the claim to correctness, which ought to be distinguished carefully. On the one hand, the claim that a certain decision, judgment, or act of a particular person or institution is in fact correct, and on the other hand, the claim that the decisions, judgments, or acts of particular persons or institutions ought to be correct. While in my view, it makes no sense to say that law itself raises the claim to correctness in the sense that it is in fact correct, it appears plausible to me that legal authorities or officials must necessarily claim, at least implicitly, that their own decisions with binding force are correct, particularly that they are compatible with obviously justifiable moral principles, because such decisions demand unconditional obedience as if they were strict moral duties categorically binding. And for the same reason, it is also evident that actually all participants of a legal order, its officials as well as its addressees, have reason to claim that virtually all legal directives, therefore law as a whole, ought to be correct in whatever way they may interpret the claim's content in particular. This leads me to the question as to the kind of practical correctness to which the participants' claims to law's correctness may be directed. I agree with Alexy that the model of ideal practical discourse provides us with an appropriate procedure for the search and choice of reasonably justifiable, or if you wish to say objectively or necessarily valid moral standards, even though one has to keep in mind that every outcome of this procedure hinges on fallible, factual, or evaluative arguments, and therefore is itself fallible. Yet I do not agree with him that law's claim to correctness is directly related to objectively or necessarily valid moral standards resulting from rational practical discourse. If law's claim to correctness is understood as a mixture of various claims that its participants are raising, either for or towards legal decisions, norms or acts, as I have proposed, then it becomes highly doubtful that these claims are based on an alleged objective morality rather than on people's own moral convictions. Sure, these convictions may come close to the results of a reasonable practical discourse, but they may also more or less deviate from them. For even though moral convictions do claim general acceptance and, in this sense, objective validity, they are, in a sense, unavoidably subjective, for they are autonomously chosen and accepted by each person at their own discretion, as there is no moral authority entitled to decree moral standards. Thus, every person is author of his or her own moral attitudes, which together form an individual morality that may more or less coincide with others' individual moralities or more or less differ from them. Since moral convictions are usually dealing with important social affairs that, differently from matters of taste, require generally binding regulation, a social community needs a sufficient consensus among its members on moral principles in support of certain ways of regulation, including legal regulation backed by force. Accordingly, we find in every functioning social community in general, and in every well-ordered society in particular, a large degree of agreement on a set of moral principles, which may be called its conventional morality. And I want to maintain that such conventional morality is in fact the kind of morality to which the participants of a legal order usually refer when they make the claim to law's correctness, even though this is not necessarily so. For if they instead rely on moral attitudes that are not widely shared, they will probably not succeed in gaining a hearing in public discussion. As a rule, people are inclined to regard their own individual moral convictions as well as conventional moral standards which they share as objectively valid, since they acknowledge these standards just because of the fact that they deem them to be generally acceptable. This situation, which emerges from morality's inherent tension between its subjective and objective aspects, gives rise to an ongoing public discussion on moral matters, which, under favorable conditions, may amount to a reasonable moral discourse that more or less satisfies Alexys' requirements, so that its outcomes could be deemed to be the best justifiable moral standards currently available. Such a discourse, however, requires, apart from everybody's existential decision to join it, a number of highly demanding prerequisites which are rarely fulfilled, for they are not only the well-known limits of practical reasoning that lead to Rawlsian reasonable disagreements, but also a lot of social and mental obstacles to a reasonable moral discourse which Alexy seems to neglect or underrate, obstacles that emerge mainly from life-world contingencies, socio-structural distortions, and political constraints of moral reasoning. Of course, these obstacles to reasonable moral thinking do in no way undermine the very idea of reasonable moral discourse as advocated by Alexy. But I think they nourish considerable doubts about his view that law's claim to correctness refers to any objective morality as a result of an ideal practical discourse. After having articulated my doubts about Alexys' view of the connection between law and morality, I would like to present now, in the third part of my paper, a rough sketch of my own ideas concerning this conception, this connection, ideas that, to a certain extent, are similar to his view, but deviate from it in the points mentioned before. I also start from the thesis of a dual nature of law, which, however, has more the form of an open frame rather than that of a conceptual anticipation of its substantial corollaries. I assume that law, understood as positive law, has two dimensions which a theory of law has to explain, namely law's factual dimension that manifests in certain empirical facts constituting its facticity on the one hand, and on the other hand, its ideal dimension that consists in law's normative force constituting its normativity. As to law's facticity, I propose to add to the two facts mentioned by Alexy, i.e. authoritative issuance and social efficacy, a third, namely social acceptance. For social acceptance is, at least from an observer's perspective, certainly a fact that greatly contributes to law's actual impact and functioning, but it is also a source of law's binding force from the viewpoint of participants who accept their respective legal norms or orders. Thus, social acceptance has also a dual nature, which may provide a bridge between the two dimensions. Anyway, I join Alexy's view that law's normativity mainly flows from a claim that is necessarily connected to it, even though I have a somewhat different reading of this claim, which I call the claim to legitimacy. The claim to legitimacy, as I understand it, differs from Alexy's claim to correctness in three respects. First, it is not raised by law itself or its authorities in behalf of it, but by its participants, including both officials and addressees, either for or towards legal norms. Secondly, it is not aiming at the highly demanding target of law's overall correctness, but to the more modest end of its fair acceptability or legitimacy. And thirdly, its immediate object is not any objective standards of correctness in general and of morality in particular, but the practical convictions and attitudes of law's participants. Thus, the claim to legitimacy is not just a single claim, but a variety of claims in a twofold way. On the one hand, it includes two different kinds of claims, namely the claim by legal authorities and officials that their own and possibly also other legal decisions are in fact legitimate, and the claim by virtually all participants that legal decisions and norms ought to be legitimate. And on the other hand, both kinds of claims include many particular claims by law's participants which, dependent on the underlying conceptions of legitimacy, may more or less coincide, differ, or even compete. Admittedly, this view makes the explanation of law's normativity a bit more shaky and complicated than Alexy's correctness thesis, but it has the advantage of being more realistic because of its renunciation of daring idealizations. The basic assumption is that law, be it a legal norm, practice, institution, or order, has normative force if its participants, i.e. its authorities and a major part of its addressees, deem it to be legitimate to a sufficient extent in the light of widely accepted practical attitudes, including strictly binding standards of conventional morality. This assumption opens up a wide variety of constellations in which law may have more or less binding force for its participants in general, up to a point where this force is so little that the respective practices may even lack legal validity. Everything what I said so far is, by the way, fully compatible with a positivist approach to law, because the claim to law's legitimacy, as I understand it, only refers to the actual participants' practical attitudes, including moral convictions, which from an observer's perspective are nothing more than empirical facts. Hence, a concept of law that accounts for law's normativity does not necessarily include a reference to an objective morality and therefore imply non-positivism, as Alexy maintains. Yet, there is a feasible way of moving from conventional moralities to something that may be called an objective, or, as I prefer to say, a critical morality. Such a move may be driven, under certain conditions, by a dynamics of moral reasoning that results from its inherent tension between every morality's claim to general validity on the one hand, and the dependence of its general validity on its widespread voluntary acceptance by the individuals concerned on the other hand. This tension causes a demand for an ongoing public discussion about moral matters, which, under favorable circumstances, may take the form of an open, informed, reflected and fairly reasonable moral discourse that approximately meets the ideal requirements of proper moral reasoning, the outcomes of which may be taken as the best justified conception of morality that can be reached at the respective stage of discussion. This move, however, is merely contingent rather than necessary, since the debate on moral matters may suffer from various distortions that obstruct a reasonable moral discourse, such as indoctrination and manipulation by mighty social forces, the impact of socio-cultural prejudices, or large social inequalities that prevent people from impartial and informed moral reasoning. This, however, is no objection to Alexys' thesis that an objective, or in my terms, critical morality, that may be achieved under fairly favorable conditions will at any rate include the basic human rights. Hence, we eventually arrive, in fact, at a connection between law and morality in the sense of an objective or critical morality that apparently exceeds the limits of legal positivism. Yet, as I said already, this connection is, in my view, not a necessary one, but a contingent relation which depends on various rather demanding prerequisites which are rarely fulfilled in social reality. Let me conclude with a brief resume on the main points where Alexys and my views of the connection between law and morality diverge, although our views have some basic assumptions concerning these points in common. In spite of the fact that we both start from assuming a dual nature of law, we significantly differ in its understanding, since Alexy attaches to it a highly substantial conception of law's ideal dimension that already anticipates his correctness thesis as well as his concept of morality, whereas I define this dimension in a more or less formal way that leaves its substantial concept open to further consideration. On the basis of these starting points, we both share the idea that law's normative force originates in its claims to appropriateness, be it correctness or legitimacy. But while this claim is, according to Alexy, a claim of law itself, it represents, in my opinion, a multitude of varying claims raised by law's officials and addressees. Eventually, we both assume that law's correctness or legitimacy requires its accordance with certain standards of morality, which, however, are conceived of by Alexy as standards of an objective, necessarily valid morality, resulting from an ideal moral discourse, whereas I maintain that law's normative force directly flows from conventional morality, which, however, may encourage a proper moral discourse that may result in a reasonably justified morality as a basis for law's legitimacy. From all these differences follows a general divergence. While Alexy insists that the connection between law and morality is a necessary one, I tend that it's merely contingent. Last but not least, I would like to underline a much bigger difference between our views. While my contribution to legal theory in general and to the concept of law in particular is of little significance, as it only consists in some occasional and disjointed pieces, Alexy has provided us with a comprehensive, well-elaborated and coherent theory of law that covers virtually all important aspects of legal philosophy. This is really an exceptional achievement, which causes me to admire Robert Alexy as an eminent scholar as much as I like him as a wonderful colleague and friend.